Cash, right? Cash talks. Are you looking to sell your patent? You want to hear about how you can make money with patents? Hey everyone, I'm J.D. Houvener, USPTO patent attorney, CEO and managing partner here at Bold Patents Law Firm. Today, I'll be talking about selling your patent and getting you everything you need to know about moving it forward. Today, I'll be sharing with you 5 steps about how to make money with your patented product. The first step of the process is identification of the parties. Now, when you're looking to sit out at the table and negotiate a patent sale or patent license, you have to know who you're dealing with. If you're an individual inventor and you're sitting across the table from another individual that's looking to acquire the rights, it's very straightforward. But things get complicated quickly if they're a company. And if that company has many moving parts, you're going to want to know who will have rights to make, use, sell, or import your invention, and how much of it's going to be licensed or sold. And now it's time to consider what the parties' intentions are. The party A, which is the one giving up their patent rights, and party B, the one receiving them. In the contract, you've got to lay it out clearly what the goals are and what is being conveyed, right? This is a transaction. The party giving up their patent right needs to say exactly what is being granted. In a patent, you've got the ability to grant the ability to make it, to use it, to sell it, and to import it. Okay, and depending on how many countries we're talking about, this is a lot of different rights. And so clarifying who's giving up what and who's receiving it is also in part of this, the major part of the patent sale. After the parties' intentions are clear, and we already know who the parties are, now let's talk about the actual rights themselves. What is it that you own? In the contract, you're not going to want to specify the whole list of claims that are listed on the bottom of a patent in the top of the contract. What you'll want to do instead is say, look at Exhibit A or see Exhibit A. In the exhibit, down at the bottom of the contract, will identify the patent number, the patent applications that may be pending, and the whole portfolio that's being conveyed. From there, each party will want to inspect each of those identified to make sure that those are indeed the patent publication numbers, serial numbers, and dates that are associated with the conveyance. The actual rights aren't going to be listed in the contract at all. You want to make sure that you look at each of those exhibit references at the USPTO.gov to make sure those claim scopes of independent and dependent rights are as you've specified and negotiated for. The next step, before you move on to the purchase statement, which of course is probably what you're all hoping to hear about, is the money part of the contract, you've got to talk about the prior or existing licenses. These are conveyances, right? Transactions that the party A, who's giving up rights, may still be under the obligations for, right? If you're one trying to license your right to party B, it's party B's job to make sure that they're receiving the full amount of that right. If you have actually licensed your invention out to someone else in the past, or you're under an obligation to assign your patent to another company, that needs to be cleared up right up front. If the party B is going to be a non-exclusive licensee, that needs to be cleared up front as well in the contract. That means that they're not going to be the only one that gets to make, use, or sell the invention. They're going to have competitors built in. Now, whether those competitors are actually going to market or not is irrelevant. It's that they could enter the streaming market against them in competition. And in that scenario I just painted for you, it's going to likely decrease the value and help them, party B, the one receiving it, negotiate down the royalty or the lump sum payment. All right, so now it's time to talk about price, right? This is the part of the contract that everyone probably scrolls down to and says, okay, how much? And you're right, this is key. This is probably the most important part of the negotiation process. What's at play here is the money in terms of lump sum, what's received up front, and what's potentially received over time, or including contingency payments. Contingency payments are when you receive money via royalty if and when a product is sold. These are terms that get negotiated. Patents can be sold outright for a lump sum payment, to where there's no license at all, it's being sold. Or the purchase price can be one that's paid for over several quarters or years, or contingent upon certain activity up to and including sale. Something else to include here in purchase price is to make sure it's not just about the revenue, you've got to get more specific. Are we talking about gross revenue or net revenue? That's a big difference. It's easy to calculate gross revenue, so that's how most deals are done. If we're doing net, you've got to really get into the business and see what expenses are at play to calculate this properly. Last but not least, once you've negotiated the purchase price and all the other terms of the agreement, now it's time to record it with the U.S. Patent Office. Recording an assignment or license is important. It helps to publish the information so that any other competitor or folks that may need to look at this later in a litigation will have the record preserved. It's also useful for making sure that deals get done and it's a clear, transparent transaction to where there's no third party that's going to be left out of the loop. This is something that both parties agree to, and it's not going to be a private transaction. It's for all their customers and all the folks that may need to see this after the fact. Look it up online in the public USPTO database. All right, we've had fun. We've talked about how to do a patent sale transaction and what you've got to think about in order to make that happen. We've talked about how each party has their own intentions and how they need to be articulated right up front in the contract. How it's no joke that you've got to make sure you do your diligence to make sure that the patents that you're buying are indeed contain the claims that you hope they do. Then make sure you've done the diligence as well to put down in writing the price point. Okay, is this going to be a royalty payment, lump sum payment, or a contingency based on some other activity or performance later on? And make sure before you close up that agreement, before you both part ways, that you record the document with the USPTO so that it's clear and transparent for all third parties later. Now you know how to make and complete a transaction, right? This is the finish line. You've done all the hard work of researching, applying for, getting your patent granted, and now you've made some money with it. Congratulations. Thanks for watching. I'm J.D. Houvener, Managing Partner and CEO here at Bold Patents Law Firm. Have a great day, everybody. Go big, go bold.